We're going to begin tonight in Miami, where we're joined by MSNBC legal analyst Lisa Rubin. Lisa was inside the courtroom today for the arraignment. Lisa, it's great to have you. I know it's been a long day already. Thanks for being with us.
Thanks, Rachel.
Let me just ask you about the nuts and bolts of what happened tonight. Obviously, we all know sort of what an arraignment is, or at least we've all had to learn it to be able to cover this particular ex-presidency. Did the magistrate judge today set any specific parameters in motion in terms of what the schedule's going to be like, what's going to happen next, or what we should expect more broadly from the trial proceedings?
He did and he didn't, right? This is a magistrate judge who, right before he left the bench, said, my involvement in this case ends just about now. And knowing that he had made perhaps the only joke of that 45-minute proceeding, got up from the bench, walked away, and presumably into the sunset where Donald Trump and his legal troubles in the Southern District of Florida is concerned. However, Rachel, he entered two orders that I think are worth discussing. One is an order concerning the production of evidence by the government. That's called a Brady order. It stands for United States Supreme Court case that requires the government to produce evidence that has the tendency to exculpate the defendant. Put in simple terms, to be helpful to the defendant, to help him in his defense. And that can be anything from evidence that would tend to reduce a sentence to evidence that would undermine the credibility of a witness. We haven't seen that order hit the docket yet, and so we don't know the timing for the production of that evidence. The rest of discovery will be addressed by Judge Aileen Cannon, or if she recuses herself, subject to a motion or even voluntarily by another judge. But for right now, that's the only evidence that's being required to be produced. The other thing that Magistrate Judge Goodman did that I think is of note is impose a condition that nobody asked for. The Department of Justice basically said it would be fine with them if Trump was not free to subject to travel limits, that he's free to travel domestically, internationally, he can keep his passport. There's not even a restriction on him holding firearms. But Judge Goodman said what really concerned him was Trump's continued ability to communicate with his co-defendant, Walt Nauta, and witnesses in the case. He recognized, on the other hand, that Walt Nauta still works for President Trump, and they interact almost every single day. And not wanting to deprive Walt Nauta of his job, what he said was Trump and Nauta can't talk about the case or the facts of the case under any circumstances. And then he was about to bar Trump from talking to any witnesses in the case. That's something against which Team Trump fought back hard. Ultimately, where it landed is the Department of Justice gets to prepare a list of witnesses that it has concerns about Trump communicating with. And Trump, subject to that list, may not communicate with those people about the facts of the case. That, of course, necessitates the question, who's going to catch them? And is this really in order with any bite? And, Rachel, that remains to be seen. The Department of Justice had 13 lawyers in court today. They are certainly not for a lack of resources in this instance.
Lisa, let me just make sure that I understand in terms of the way this went and who was asking for what and how the magistrate judge decided today. Was there anything the Department of Justice, the prosecutors, asked for today that the judge said no to?
Absolutely not. In fact, the judge of his own volition is the one who raised the concern about Trump communicating with other people. The Department of Justice appeared to be very happy to go really easy on Donald Trump as a defendant in terms of the condition of his release. It's Magistrate Judge John Goodman who was the one who had concerns. And that's not unusual. In fact, he said it's typical in this district where you have co-defendants to prohibit them from speaking to each other. I experienced that in private practice myself when I defended someone in a securities conspiracy case. My client, who was a law firm partner, and his client, a then CEO of a company, were not allowed to continue talking to each other, even though as of until the moment of their arrest, they were still in a working relationship together. But Judge Goodman seems sympathetic to the fact that Walt Nauta would be out of a job if Donald Trump couldn't communicate with him, and that was one step too far for him.
Fascinating. MSNBC legal analyst Lisa Rubin. Again, I know it has been a long and intense day already. Thanks for being with us tonight. That was super interesting, my friend. That was really fascinating. I want to go to all of you guys on this. Ari, let me go to you first. Lisa was there. Garrett Haake was there in the courtroom. We've had descriptions from them about some of the things that happened in the courtroom and also just sort of what it felt like, what was unusual, if anything. Have you heard anything about the way this court proceeding went today that stands out for you as potentially important in terms of the way it's going to go in the future, or just as unusual given who the defendant is in the case?
Only that it was longer than usual. Federal arraignments, like local arraignments, tend to be super quick.
Yeah.
And because of the back and forth we just heard about, it went much longer than usual. And he was given a slight amount of deference, but not an inappropriate amount. In other words, the mugshot is not supposed to embarrass. It is a identification technique. I think it is fully reasonable for the federal government here through the Justice Department and the courts to say, the defendant's been identified, and so they didn't do that. Nicole and I were talking today. I mean, he left a lot of fingerprints on the documents, on his attempts to lie to the government with his lawyers. And now today, he got fingerprinted. And so there is that very real aspect of this where it doesn't mean he's guilty. He's legally presumed innocent. But he is being treated under the law as a defendant with all that comes with that. So he's not in control in the courtroom. He was quiet. He had the lawyer enter the plea. He was forced to sit there quietly. And they have means, which is why he knew to be quiet, to enforce that in the same way he was under the control, under the booking and arrest of the United States government. So for a time today, for the first time ever, the federal government that he used to run was basically supervising him, and there's a lot more where that came from if you are convicted.
Can I ask Aria a question, if you don't mind? We're just going to interrogate Aria. Because I can't wrap my head around the Waltine Nauta, Donald Trump situation. So they're sitting there together. At one point, Nauta's lawyer, the one he has, he couldn't even complete the process because he doesn't have a lawyer that has a bar license in the state of Florida, starts talking with Trump's lawyer. So their lawyers are talking. Then Nauta marches out behind Trump. Lisa Rubin painted the picture. It was very strange. He walks out, he lines up behind Trump and immediately resumes his position as valet, walks out right behind him. He came to this proceeding in Trump's motorcade. He is going to go back and continue to work for Donald Trump. His lawyers are paid for, at least to the extent he has lawyers, by Donald Trump's PAC. How in the world can you enforce an order that they can't talk? He literally is his subordinate, his employee, and almost sort of, it's almost he's his, man Friday. How does he not talk to him, and how does he not intimidate Waltine Nauta?
Well, great question. Number one, Joy, as you're alluding to, there is a dual role or potential conflict in this individual being a defendant on a co-conspiracy and still being the employee and having other services, legal and otherwise, paid for by Donald Trump. Now, that's not illegal, but it is what we would call a tension there. And then second, how do you enforce an order like this? The short answer is it's hard, but let's not forget what Jack Smith got a hold of. He got a hold of lawyer notes and other materials that Donald Trump thought would long remain secret because of the lengths they went. So while I agree with what I think is the premise of your question, which is this is going to be hard to enforce, if they talk about it in ways that other people hear or the lawyers hear or are, again, involved in ongoing crimes and violating this order and or trying to plot to suborn, perjury, etc., would be a new crime.
Yeah.
And anyone gets wind of that, yes, that could become a note, which could become a tape or an evidence item that is used against them.
Seems like something that would be hard to discern if they broke that rule, but if they did, it would be so high consequence for them that there has to be some deterrent fact, given that it would be immediately in front of a judge.
Yes, although I don't know what deters Donald Trump. I mean, that's sort of the big,
never been a federal criminal defendant before. We'll find out.
That's true.